be seated. The sole case we appear to have on the docket this afternoon is styled In Re Accetta versus Brooks Towers Residence Condominium Association. Both sets of counsel look like you're positioned and ready to go. When the petitioner's ready, go ahead and begin your argument.
Thank you, Chief Justice Coates. Good afternoon, and may it please the Court. My name is Dustin Preby, registration number 36850. I represent the petitioner, Anthony Accetta, in this matter. This case concerns Colorado's Common Interest Ownership Act, or Kiowa, and this Court must decide how onerous are the procedural obstacles that a Colorado condominium owner must overcome to remedy a violation of Kiowa and to stop the actions of a homeowners association that are contrary to Kiowa. Can that relief be obtained through efficient litigation with the homeowners association, of which, by statute, every unit owner must be a member? Or must the harmed condominium owner first sue every other unit owner individually as an absolute condition to stopping even the clearest violations of Kiowa? The answer is no. A condominium owner is not required to individually sue all of his or her fellow owners to correct Kiowa violations or to rectify illegal provisions of the governing documents. This type of mass joinder is not necessary for three reasons. First, it's contrary to the objectives that Kiowa seeks to achieve. Second, it's contrary to the objectives sought by the rules of civil procedure. It ignores the existence and composition of a homeowners association, and it then conflates concepts of voluntary intervention in a lawsuit with involuntarily being brought into the court as a defendant. Third, the policy implications of such a joinder requirement are staggering, and it would benefit no one. The rule plainly harms the aggrieved unit owner, but it also harms the unit owners who must be personally named in every Kiowa lawsuit, as opposed to having an option to move to intervene if he or she disagrees with the approach taken by the unit owners association. That imposes very real costs on the unit owner. Further, many Kiowa violations would go unaddressed. Those cases that are litigated would cause an unnecessary burden on the trial court and the litigants and could go on for years. As it relates to the specific facts of this case, Mr. Accetta is paying over 50% more for common expenses than comparable units. This is because the pertinent declaration for his condominium complex does not contain a proper formula for allocating these expenses as required by Kiowa. It instead provides that the allocation is based on a concocted value of units that was determined in the sole and arbitrary determination and discretion of the declarant. Mr. Accetta brought suit to correct this overcharge, and the association argued the case could not proceed unless all owners were joined individually. The primary basis for this argument was a 2008 Court of Appeals case, Fairway Pines. Specifically, Clubhouse at Fairway Pines, LLC, v. Fairway Pines Estate Owners Association. The court in that case ruled that whenever a lawsuit involving a common interest community requires a declaration concerning the interpretation of the governing documents, and there is a potential for unit owner disagreement, then all the individual owners must be separately named as parties. The trial court found that precedent controlling and ordered the joinder of the individual unit owners here as parties. This court issued a rule to show cause as to why the court's joinder order should not be vacated. And there are three reasons, as previously listed, why Fairway Pines is incorrect and why this court's rule to show cause should be made absolute. We'd like to discuss each of these 3 points, the first being what the basic intent and concept of Kiowa is, the second being the basic intent of the Colorado Rules of Civil Procedure, and the third being the public policy ramifications of requiring all unit owners be joined to lawsuits of this type. As it concerns the first justification, joinder of the individual units with respect to the provisions of Kiowa. Section 301 of Kiowa requires that a unit owners association be formed before even one unit in a condominium complex is sold. It's an absolute requirement. Kiowa also requires that this unit owners association contain all of the unit owners, and it further provides that only the unit owners can be members of the association. The Owners Association, as set forth under Kiowa and as required by that statutory scheme, is very unique in the law. It requires that every single condominium owner be a part of it, and it requires that only the condominium owners be a part of it. Kiowa then contains a number of strict requirements, among them what must be included in the declaration, including an appropriate allocation of percentage ownership interest in the common elements. Kiowa further provides that its provisions cannot be varied by agreement and that its rights cannot be waived.
Mr. Prevey, let me cut you to the chase because your time is short. You argue that 33.1311 applies here, and I'm not quite sure how it applies. It's one of the questions I think we asked you all to be ready to address. That section deals with any action alleging an act or omission by the association must be brought against the association, not against a unit owner. Why is this a challenge to an act or omission by the association as opposed to a problem in the declaration?
In Justice Gabriel, we think it is a problem with the declaration. And with respect to Section 311, we believe it applies because the Unit Owners Association is enforcing, we believe, the declaration in contravention of Kiowa. But the more important purpose for citing Section 311 is really the role it plays in the overall scope of Kiowa as a whole, when you're reviewing the entire statutory scheme as a whole. Kiowa itself requires that the Unit Owners Association, requires that all the unit owners be a member of the Unit Owners Association. Beyond that, it provides for certain rights that cannot be waived. And Section 114 provides that all of its rights and obligations can be enforced by judicial proceeding. With respect to Section 311, which the court mentioned, that further provides that with respect to certain actions, those actions can only be brought against a homeowners association. They can never be brought against individual owners. Section 302 of Kiowa further provides the homeowners association with the ability to defend certain lawsuits, even though those lawsuits only concern the rights of certain individual unit owners, not the entire complex. We believe that when those are read in conjunction, the intent of Kiowa is that the Unit Owners Association does represent the rights of unit owners. And beyond just representing the rights of unit owners, it is the collection of all unit owners. And to require that, to enforce one of Kiowa's primary provisions, one of the primary protections that it offers to unit owners, that somehow the procedure for that must be more onerous than certain other lawsuits involving people who are not even part of the community, we believe doesn't make any sense. We believe that's contrary to the purpose of Kiowa.
Well, in this lawsuit, can the Homeowners Association represent the interests of all of the unit owners? If the costs borne by your client go down, won't someone else's costs go up?
Well, and I think that's true. To the extent that our client is, that my client is going to be paying less in HOA dues, I think it makes sense to assume that the dues paid by others will increase. But I think that's a different issue with respect to whether or not the HOA can adequately represent the interests of the homeowners. First, and we believe this is an incredibly important point, the Homeowners Association doesn't just represent the collection of homeowners, it is the collection of homeowners. It's the board who represents the Owners Association. To the extent that any unit owners disagree with a cause of action or an argument made or a position taken by the HOA in the Owners Association, all that's doing is that's creating a potential for intervention.
But how do you deal with Rule 57J? When declaratory relief is sought, all persons shall be made parties who have or claim any interest which would be affected by the declaration, and no declaration shall prejudice the rights. I mean, the problem is if somebody else, arguably, if somebody else's assessment is going to go up while your clients go down, they're affected by the declaration your clients are seeking. So 57J would suggest they have to be joined.
And the response I would have to that would be actually 3 points, Justice Gabriel. The first point would be that every unit owner is a party by virtue of the Homeowners Association being a party. We then
Isn't that the representative standing that Justice Hart was just asking you about then? You're saying that the association can represent everybody else so we don't have to join them.
Well, the association itself, the Owners Association, is the collection of all unit owners. And with respect to litigation concerning whether or not the governing documents are valid, I think that's not only the proper party to sue, but I think that all unit owners benefit from having that be the one party who would be sued. And to the extent that any unit owner disagrees with respect to the position that the HOA is taking, that would provide a basis to potentially intervene in the lawsuit on the basis that that unit owner did not believe his or her interests were being adequately represented. But the concept of because something that would happen in a lawsuit involving the HOA would impact the rights of different unit owners, that's a justification for adding on every single unit owner. That creates an incredibly, we believe, dangerous precedent, and one that would make common interest community litigation unduly burdensome.
I understand the policy argument, but tell me why 57J doesn't require exactly what you said would be the problem.
Well, I believe Rule 57J, those requirements are met by the existence and the fact that the Unit Owners Association is a party to the case. And the Unit Owners Association is the collection of all unit owners. In this regard, it's not just representing their interests and their rights, it actually is the collection of unit owners themselves. And anytime we're looking at cases under 57J or Rule 19, a lot of those rules were passed at a time before the concept of an HOA was even in existence, before the concept of condominiums were even in existence. A lot of the rulings in court cases that are interpreting Rule 19 and Rule 57 do not apply and do not do so in the context of condominium litigations or dealing with homeowners associations. And if you take the existence of the homeowners association, which is the collection of all unit owners, and you assume then that they are placed in, that they are a part of this litigation by virtue of the HOA being a member or being a party to the lawsuit, then the issue of adequacy of representation really becomes one that's more justifying intervention. And to the extent that any unit owners believe that the positions taken by the HOA, they disagree with them, or they believe are not representing that unit owner's individual interests, that may provide the ability to intervene, but it does not require that the individual unit owners be named parties individually. And circling back to the policy ramifications of that, a lot of the reasoning set forth by the HOA for why the individual unit owners need to be named individually is to avoid prejudice to those individual unit owners, to avoid prejudice and that somehow their interests are being harmed. But it's difficult to ascertain how a unit owner would be better off being involuntarily brought into a lawsuit as a defendant anytime there's an issue with the validity of the governing documents or whether they apply with Kiowa, as opposed to having the HOA take a position which that homeowner can then either agree with or disagree with. And there's plenty of remedies if the homeowner disagrees. If the unit owner disagrees, they can certainly move to intervene. But it's difficult to ascertain and to determine how a unit owner would be less prejudiced by that course of action, as opposed to being involuntarily named as a defendant every time there's a dispute by one of the unit owners about the validity of some component of the declaration.
Well, what do we do about the fact that the HOA is the one who said, we can't represent everybody, you got to bring them all in? We would have conflicts of interest. I mean, there are different views of all of our members, including your clients who are members. What do you do about that? Your position is they represent everybody. They are all the owners, so we're representing everybody. I think their position is we can't represent anybody because we got owners debating with each other.
And we would disagree with that contention, Justice Gabriel. We would disagree with the idea that a homeowners association can come into litigation and effectively say, well, we think all of our homeowners could potentially disagree about whether or not the declaration is or is not valid. So we're going to withdraw and not take any position and say that this is just something all the unit owners need to litigate.
Well, let's say, and I'm just obviously playing devil's advocate with you here. Say hypothetically, we don't have just your clients in their position, but there are other members of the association in their position whose assessments would go down by this lawsuit, but they're not parties to the lawsuit. That would put, so we're not talking hypothetical. The association actually knows that there are people who are not parties to this lawsuit. Some have the assessments too high, and some are going to get hurt if the declaration is entered. What do they do then?
Well, I think the path there is fairly simple, Justice Gabriel. And the concept would be the HOA is going to take whatever approach it believes is appropriate. In this litigation, we believe the association has pretty clearly indicated they intend to litigate and try to uphold the validity of this declaration. Once they notify homeowners of that intention, once they notify them of the dispute, which they're also required to do under Kiowa to keep all the unit owners informed, all of those unit owners can make an intelligent determination as to whether or not they would like to intervene to protect their own interests, or whether or not the existing parties to that litigation are already adequately representing their interests.
Has that actually happened in this case already?
And Justice Hart, which portion of that?
Have they given notice to the other members of the HOA?
I do not know specifically. I know that the other members of the HOA have been informed of this lawsuit. I don't know the degree to which the other unit owners have been informed of the nature of this lawsuit or the specific request that it's seeking, although not, I believe it's included in the record, but we had filed a motion shortly before this writ was granted for permission to get the email addresses of all the different unit owners so we can ourselves inform them of what's happening with the lawsuit. At this point in time, we have not yet been able to do that. But in terms of the appropriate procedure going forward, the one that is least prejudicial to everyone and benefits everyone, frankly, the procedure is the HOA can take a position. And we do not believe the HOA should be allowed to just sit back and say we're not taking any position, enforce all of its unit owners to just become parties individually to litigation. The Unit Owners Association should take a position. It should inform the homeowners of what position is being taken, and that will provide all of the homeowners with the ability to intervene if they choose, if they believe that one of the parties to the lawsuit is not adequately representing their interests. And when we look at what's happening in this lawsuit specifically, the HOA is arguing that all the individual unit owners need to be brought in to prevent prejudice. But there's no real articulation of what prejudice any of them are experiencing as a result of not being named individually. And if you take a look at cases decided in recent years that concern the validity of declarations, and litigation concerning the validity of a particular provision of a declaration, or whether or not an HOA's actions have violated Kiowa, none of this is particularly new or novel. These cases happen all the time. Numerous ones are filed every year. Many of those cases simply involved the allegedly aggrieved homeowner and the Unit Owners Association. That's how almost all of these cases proceed.
Mr. Priebe, can I ask you, what happens if you prevail in the lawsuit? Do they just declare does the judge just say the declaration is invalid, or does it reform the declaration?
Well, I think it would almost go in separate steps. The first determination is, does this declaration violate Kiowa? Does it not comply with Kiowa, the allocation? And the Unit Owners Association will take one position, we'll take another, and we'll obtain a ruling on that. And we believe our client is entitled.
Let's assume you prevail.
And if we prevail in this case, then the second step will be the interests somehow need to be reallocated. And reallocated is probably not the correct word because reallocation suggests there's an existing allocation, which we believe there's not. But the Unit Owners Association, again, would be able to take a position to say, in the event that a provision of the declaration fails, what is the appropriate course of action for this community?
Well, would the community go back and see if they can reform it to make sure it complies, or would the court enter an order reforming it?
I think there's multiple different ways that can proceed. I think the court could enter an order reforming it, but certainly like any other mechanism of litigation, once it's determined that provision of the declaration is invalid and the allocation is invalid, the parties would certainly have the ability among themselves to try to reach some type of an agreement. But to the extent that they do not, then the association could take one position with respect to what it believes to be an appropriate allocation to comply with Kiowa in light of the fact that the existing declaration provision has been found to be invalid. That would be something that would again be made known to the court, would be subject to this litigation, would again be disclosed to all the different unit owners, and any unit owner who disagreed with that allocation could simply move to intervene if they disagreed, or if they believed that, no, we believe this is a more appropriate basis for the allocation, and they could step in. It's also entirely possible that if it was just done on a square footage basis, which is common in many different condominium communities, perhaps no one would move to intervene, perhaps no one would object. But the concept of whether or not the court can reform the declaration, we believe it can, and that would effectively follow the same format that we're following with respect to declaring this provision of the declaration void or invalid as conflicting with Kiowa. Again, with full notice to all of the unit owners and allowing them the ability to intervene if they chose, if they believe the position taken by either my client or us in this litigation or the Homeowners Association does not adequately protect their interests.
And just to be clear, the complaint, as I understand it, seeks a declaration that the current provision, or the 3B and 20A are both void as contrary to Kiowa, but also seek a declaration of the rights and responsibilities of the party and a reformation of the declaration, right?
And that is all true, Justice Marquez. And the complaint itself seeks a number of different types of relief. Obviously, some of those are pled in the alternative because our client's primary complaint here is to not be overcharged in violation of Kiowa. And I think there's a number of different ways you can get there. Certainly one of them is just reforming the declaration. And to the extent that the declaration is reformed and that alleviates any of the problems that would require any other declarations, then a number of those claimed reliefs would be in the alternative.
And one other quick point of clarification is your point about intervention seems to be slightly different than the position you were taking in the briefing, suggesting that permissive joinder would be the solution here. And I'm just trying to reconcile that.
And permissive joinder could be as well. I think there's a number of different mechanisms for, depending on who has the concern. Correct? If somebody would like to join into a lawsuit permissively, they're entitled to do that. An intervention would also be another path forward. So I don't want to somehow just limit it to intervention, but I just want to give that as an example for a different mechanism to alleviate the concern that if somebody wants to have a voice or if a different party believes someone needs to have a voice, there's other mechanisms to bring them in other than saying that as an absolute prerequisite to the plaintiff continuing and pursuing with its claims, it needs to go name absolutely all of these individual unit owners. And just circling back to what we were discussing, and to what I was discussing in terms of the impetus and the basis for this lawsuit, it's very rarely argued by a homeowners association that the homeowners association itself cannot take a position with respect to a particular HOA provision. These cases are located and arise every year. They're decided by courts routinely. It's a unique position for the HOA to take. And the cases that we're looking at, and this one in particular, I think indicates the reason why that is being argued and brought forth. The primary motivation here, I believe, for arguing that all the individual unit owners need to be made a party is to create a significant procedural hurdle to prevent Mr. Accetta from reaching the merits of this case. And that's why this argument is not seen in many other HOA cases. To the extent that this was raised by every homeowners association, this would be a significant issue that's litigated routinely. It would almost be the first issue raised in any piece of litigation concerning a common interest community. It's not there, and the reason is because it also really does not benefit common interest communities. It doesn't even benefit the homeowners association. When it's used and when it's seen, it's typically seen in cases like this, where the argument is raised not as a mechanism to prevent potential prejudice, but as a mechanism to defeat an otherwise meritorious suit through significant procedural hurdles. And if there's no other questions from the court at this time, I'll save my remaining time for rebuttal.
Okay.
May it please the court, counsel. I'm Ron Nimero. I'm here on behalf of the respondents, and with me is Miles Buckingham. My number is 15178, and Mr. Buckingham's is 31303. In setting this matter for oral argument, the court asked us two questions. The first was, is the validity of a declaration an act or omission by the association, as that phrase is used in 311.1? And the second question was, can unit owners not joined claim prejudice from the rectifying of an illegal declaration provision? Or is the illegality of a declaration provision an issue on which the association can adequately represent the interests of absent owners? At the risk of removing any suspense at all from my presentation, let me answer those questions right now. The validity of a declaration is not an act or omission by the association, as that phrase is used in 311.1. Second, the answer to the question, can unit owners not joined claim prejudice from the rectifying of an illegal declaration provision? Or is the legality of a declaration provision an issue on which the association can adequately represent the interests of an absent owner? That question I object to as compound. But I'll answer it in reverse order. Yes, the legality of a declaration provision is an issue on which the association can adequately represent the interests of absent owners. In fact, the association is bound to defend the declarations. The association is a creature of the declarations. That's what the association can do. But can owners not joined claim prejudice from the rectifying of an illegal declaration? The answer to that, too, is yes. If there's ultimately found to be a problem with the declarations, the solution will ultimately prejudice some unit owners and will benefit others. And that's something the HOA can have no part in.
Why is that legal prejudice? And good afternoon, Mr. Nemro. At some level, wouldn't the court just be rectifying a windfall? If people are being assessed the wrong amount and getting a benefit because the declaration provision is illegal, then when it gets fixed, they lose their windfall. How is there legal prejudice in that?
Well, I think there'll be a disagreement among the owners as to what constitutes a windfall. And people with gains, however ill-gotten, who have them removed, generally consider themselves to be prejudiced.
Well, they may consider themselves to be prejudiced, but as a legal matter, do they have a legal entitlement to an illegal declaration?
Well, they have, the declaration is a property, is pertinent to property interests. The removal of the property interest would be prejudicial. And to the extent that there has to be a fair allocation, there would be each homeowner, each unit owner has its own interest in what constitutes a fair allocation. For example, the other unit owners on the third floor are comparably situated to Mr. Accetta. They may benefit. The remaining owners, unit owners, may be prejudiced. But that is a debate over how the pie is sliced. And the Homeowners Association cannot get into that debate. It is prohibited by doing so by the declarations. There are, paragraph 18A of the declaration says the Homeowner Association must act in compliance with the declarations. Paragraph 19A of the declaration prohibits the association from changing pro rata interests or obligations. And paragraph 31B prohibits the association from changing allocated interests of a unit without obtaining 100% consent of 100% of the owners. So it may be that justice will be done, but the Homeowners Association, as an association, can have no part in that, because that involves differing interests on the part of the owners that constitute it.
You finished?
Yeah.
Yeah. Mr. Nimmer, let me just turn your attention back to 311.1. Can you respond to opposing counsel's argument that 311.1 still applies because the Homeowners Association is enforcing the declaration, so the association remains?
Well, I can. 311, the answer to the question as phrased about whether the declaration is an act of the association, I'll get back to answering that, I guess, later. But to answer your question about whether the association can be involved because of 311, that statute doesn't apply, because that applies to torts and contracts, not just by the title, but the substance of the statute applies to torts. The first sentence applies to torts, and it doesn't make sense to apply that statute in this context, because this is a declaration that was written decades ago. And it was written it was written well before Mr. Accetta bought his unit. And seeking indemnity from the declarant doesn't make sense under those circumstances. Moreover, if that statute applies, then the contents of a declaration isn't an act by the association. It's not mere semantics to suggest that a declaration is, by definition, an act of a declarant. And don't take my word for it. Look at the complaint. The complaint in paragraphs 15 through 19, 25 through 27, and paragraph 45 all blame the declarant for the declaration. And it's not just the complaint. Although things have changed throughout this litigation, this has been a constant in Mr. Accetta's theory. In his reply brief, he writes, "The unit owners did not prepare the declaration. Like all declarations, it was unilaterally created by a single declarant and imposed on unit purchasers." And it's hard to see how the association can even provide the remedy that Mr. Accetta demands. Because, as I said, the declaration prevents the association from getting involved in these matters.
Well, Mr. Nimro, if this action proceeds and if a court finds that the declaration is a violation of Kiowa, then the court would order some sort of reformation of the declaration. Are you saying that in the face of a court order to reform the declaration, the HOA couldn't act?
Yes. I'm saying the HOA is not able to reform its own declaration. That's what the unit owners do.
Could I ask a question about 311? I'm still a little bit mixed about your two positions, but take it as if your opponent is not saying 311 applies, which is actually what I understood him to be saying, but rather it's something in the nature, along with other provisions, indicating that an act or omission by the association, whether it benefits some and hurts others of the unit owners or not, that is, affects them differently, nevertheless indicates that it is the association and not the unit owner that is to be named as the party when what's at issue is an act or omission by the association. I guess one way of saying that is the attempt there to say the statute recognizes, at least in this kind of instance, even though that may not be what we have, that the association can represent the interests of the different unit owners, even though they may not all be the same interest?
I don't think so. I think the association can represent the unit owners when those interests are all identical. And those cases are cited in Mr. Acetta's briefs. Those include the Pulte Homes case, the Ryan Ranch case, the Francis case, and I forget the other case. In all of those cases, the interests of the association unit owners are identical because the association is treated as a whole. However, in cases like Dunn, Good versus Bear Canyon, Clubhouse, this case, in these cases, the interests of the unit owners are potentially at odds with one another. This case presents the clearest scenario of all those four cases, because in this case, it's a zero-sum game. But whenever the issue, this hasn't been a problem. The Court of Appeals has been consistent in reaching this conclusion whenever it's been raised, that when litigation involves the differing interests of unit owners, then the unit owners all have to be made parties. And it's only fair because all the unit owners have a property interest.
Well, let me push back a little bit on you, if I can, Mr. Nimro. I guess the question is how we define what the interest is here and what the issue is. I think at some level you're going to what the result would be. Some assessments are going to go up, some would go down. Another way to look at this might be that the issue here is the lawfulness of the declaration. And everybody, arguably, and push back, would have the same interest in making sure the declaration is lawful.
That may be, but that's not what the complaint says. If the complaint were only about the lawfulness of the declaration, if the complaint didn't seek reformation and didn't seek remedies based on reformation, this would be a different case.
All right, so and I appreciate you saying this, so if the I'm going to feed back to you what I think I just heard. If the declaration or the complaint here only sought a declaration that whether the declaration was lawful, that would be okay. The association could take a position, we don't have to join everybody.
Yes.
But because they're seeking reformation, then you have to join everybody.
Yes. And it's because that involves allocating a closed set of resources. And that is precise, that would be a violation of the fiduciary duty that Mr. Accetta alleges as one of his claims, that we're not treating the unit owners impartially and equally.
Is it possible to bifurcate the proceedings? In other words, we don't get to reformation unless and until there's a conclusion that these provisions in the Declaration violate Kiowa. And the HOA, as you just said, can represent all unit owners with respect to the legality of that provision. It's only once we turn to the second part of the relief requested, reformation of that provision, that we need to bring in other unit owners.
Well, this case went up in its early stages before we've even answered. So to answer the question, is it possible? If it's remanded, I don't know. I haven't considered that question. I don't know if bifurcation is suitable under those circumstances or not.
Well, let me follow up on that. If there's a determination that the declaration here is valid, it's legal under Kiowa, then is that the end of it?
Well, even that question is in media res, as it were, because our contention is that this is a pre-Kiowa community and not subject to the requirements that Mr. Accetta claims it is subject to, because it was created initially prior to Kiowa's creation. So I don't want to prejudge the outcome of that issue.
But let's assume that, hypothetical, let's assume the declaration is valid, that it's found to be lawful.
If the declaration is valid and found to be lawful, that would be the end of the story.
And the association can represent all the unit owners with respect to that question. You agree with that, correct?
If that were what the complaint said,
if that were the only question, then...
If that were the only claim asserted in the complaint, I don't think that there would be a conflict that would require the necessary and indispensable parties argument. But that isn't the complaint that's before the court.
Let me take you down a quick rabbit hole. Bear with me for a moment, if you will. If 311.1 does apply, and there's tension between 311.1 and 57J and the statute, 1351.115, why doesn't the statute 24205, that's not discussed in the briefs, which kind of surprised me, 24205 is the one that says that a specific provision should trump a general provision. So I find myself wondering why the parties haven't discussed that at all, and maybe I'm just missing something, but if there is that tension between 311 sub 1 and 57J and the statutory counterpart to 57J under Title 13, why doesn't that interpretation statute have some application here?
You catch me flat-footed.
Okay.
I'm not prepared to discuss that statute. It's not in my packet.
I thought maybe there was a conscious choice here not to talk about that at all. Maybe opposing counsel on rebuttal can enlighten me a little bit.
Maybe, and if so, I would like leave to respond later because I know nothing about that.
I'll leave that to the chief.
Okay.
Yeah.
One point that Mr. Preby made that I think bears some remark, and that is the idea that notice under the declarations somehow substitutes for notice pursuant to Rules 4 and 5, that somehow serves as service of process. That's definitely not the case under Kiowa. Under Kiowa, when the legislature wanted to make the Homeowners Association a substitute for service of process, it said so expressly. And I would direct your attention to a statute that that Mr. Accetta did refer to in his reply, and therefore I've read it. And that is 33.3, 107.3. 107.3 expressly provides that in matters of eminent domain, the HOA, service on the HOA is service on the individual owners. But it's limited to that. The legislature is very particular about what notice is required under other circumstances under Kiowa. For example, when the HOA, when it's permitted to, when it seeks judicial amendment of the declarations, the statute is specific about what that notice must consist of. But the notice requirement that Mr. Preby refers to in the declarations is just a requirement that the HOA keep its unit owners up to date on the HOA's affairs. It's inconceivable that given the care that the legislature gave to notice in other aspects of Kiowa, that it meant the notice under the declarations should be a catch-all notice and a substitution for service of process, such that the other unit owners would be bound by the determination, by the ultimate resolution of this case. The remedy that Mr. Accetta seeks, if given by this court, would be available to every other unit owner, and it would subject the HOA to the prospect of potentially perpetual litigation from every unit owner until the declaration is just right so that everybody's pleased. There's a way to do this under Kiowa, and that's the amendment process. Then the amendment, and under the declarations, it requires 100% consent. If, as Mr. Accetta contends, the interest of the other unit owners is de minimis, then why would they withhold consent to the amendment? If it's not de minimis, then they need to be brought to the table. Now, it's not enough to say they might have notice because somebody might mention it in the hallway of Brooks Towers condominiums. It is a pillar of jurisprudence that notice for the purposes of binding strangers to litigation has to be formal. And it requires service of process. If someone is going to be bound to litigation that involves their rights. And that's all that we're seeking to uphold here. We're not looking for a change in the law. Indeed, the precedent that Mr. Accetta is objecting to has been in place for 18 years, since Dunn. And it's been a consistent outcome of the Court of Appeals whenever the issue arises. It doesn't require any change to the law. And indeed, if, as Mr. Preby said, these issues come up all the time, why then isn't there a case that supports his position? If not from Colorado, then from someplace else in the country. The idea that notice to the association is somehow notice to each and every unit owner individually would render the notice requirement in the easement statute redundant. Why would you need that if that were the case? So, in closing, we urge the court to discharge the rule because the outcome at the district court was perfectly consistent with Colorado jurisprudence, with the rules of civil procedure, and with Kiowa. Kiowa, by the way, recognizes the importance of property rights. That's why in the Robert Francis case and in D.A. Mountain Rental, requirements in HOA declarations for unanimous consent regarding changing property values, property rights, and expenditures, those requirements have been upheld because they are property rights. That is what's consistent with Kiowa. What Mr. Accetta urges is a departure from Kiowa. And what Mr. Accetta urges is also flies in the face of what Kiowa specifically prohibits courts from doing. And in 217, in 217, 7E, that prohibits district courts from amending, even at the association's request, declarations in a way that change property rights, except under certain circumstances.
So doesn't that count, and I'm sorry, I'm ruining your big finish. Doesn't that counsel in favor of if there's a reformation needed, the court orders the parties to reform and go back, and that's the end of it, as opposed to the court rewriting the declaration? I'm struggling because I hadn't considered the point you raised as to why joinder is needed because there's a claim for a reformation. And here I look, the reformation is just reform to comply with the requirements of Kiowa. What if the declaration just said, declare that the provision is illegal and must be reformed, period, or needs to be sent back to the association to let the owners reform? Could the court do that? I guess I'm sorry, I'm thinking out loud. But it strikes me that all the the declaratory judgment is asking for is tell the parties you got to reform this because it's unlawful under Kiowa. And I guess I'm not sure why all the parties have to be joined for that. And the point you just made me think of that. I mean, the court can't do it, it seems like, so the parties have to. So the court is limited to say this needs to be reformed, period.
If the declaration needs to be reformed, the association is powerless to do it. It's the unit owners.
Sure, but why do all the parties have to be joined? And again, I'm just thinking out loud with you. Why do all the parties need to be joined if ultimately all the court can do is order that the parties reform the declaration?
Well, the court, it would seem, and this is going somewhat afield, it would seem difficult for the court to order the HOA to do something that the HOA is powerless to do. The HOA can't reform its own declaration.
Although the HOA can kind of set a meeting, we've been ordered to reform the declaration and follow whatever the declaration requires to reform it. I mean, you can't order a specific, we couldn't order Mr. Accetta individually to reform the declaration either.
Well, that's right, but the court could order reformation if all the unit owners were parties.
And I guess I'm struggling with why you can't just tell the association the declaration needs to be reformed, and then the association needs to follow the format to do it, to amend or whatever else.
Because there's no way to compel the HOA to do it.
Why not? I mean, it would be the HOA that sets a meeting, right?
The HOA can set the meeting. It can lead a horse to water.
Right. And if it chooses not to do anything to comply with the order, all the procedural steps to a reform, it would be in contempt if that was the order, wouldn't it?
But it seems hard to hold the HOA in contempt for something it can't compel, that it's unable to do.
Okay. Thanks.
Is that, Mr. Nimero, is that because you have to have 100% of the homeowners to vote to change something?
Well, if you had one person
say, no, I vote against it, then there wouldn't be any reformation. We'd be right back where we started.
Right. That's partly it. Partly it's because the provisions of the declaration prohibit the HOA from getting involved in the allocation of rights and
isn't that the determination of rights? I mean, it could open the slate and have people vote, right?
Right. It could have people vote, but it can't compel an outcome.
Well, how would it change if we had all the unit owners in the case? We could order the declaration be reformed, but let's say somebody said, okay, I'm not agreeing to that.
If the unit owners were all in the case, then the court could fashion a remedy that would bind all of them.
I thought you said the court doesn't have the authority to amend the declarations and can't reform it. It has to be all the unit owners that can reform the declarations.
The court doesn't have the ability to amend the reformation to change property rights and obligations. It can amend the declarations in other ways. So you're right. In that way, it's sort of the court and the association is caught between a rock and a hard place. But the court could require, or I don't know what the court could do, given the remedy that Mr. Accetta seeks.
Well, counsel, if I want to come back to something we talked about earlier. If the court were to find that this declaration is illegal, I guess I'm still not persuaded that owners could have a property interest in something they had no legal entitlement to. So I don't think it would be.
They have an economic interest. They may, I don't know the answer to whether there would be standing because the owners would be aggrieved, having lost an economic interest. They would have to be bound by the outcome. To be bound by the outcome, they would have to be made parties. They wouldn't be bound by the outcome if only the association, if the association was the only party. Is that responsive?
I'm not sure, but.
Okay. I want to sit down before you think of other questions.
You better sit down quick.
Okay.
I'd like to briefly touch, before I get into anything else, on Justice Hood's question about the priority of the statutes between 311. And I believe we had mentioned somewhere in the briefing, in terms of the more recently passed statute does take precedent. It may not have been mentioned because of the provision 319 in Kiowa. And 319 of Kiowa provides that any provision that Kiowa itself takes priority over any other legislation passed in Colorado, whenever passed. So we believe that would have handled that issue as well. But certainly, Section 311, to the extent it applies, would be the more recent as well as the more specific statute. To clarify some of the points and to address some of the points that counsel for the HOA was discussing.
Mr. Privy, could you please make sure you cover the issue of your request for reformation and the requirement of joinder? Don't run out of time, because I'm very interested in hearing about that.
Yes, Justice Gabriel. So the request, and I think the court has summed it up accurately, the first request here is effectively that the declaration is void. Overcharging Accetta violates Kiowa. And as I believe counsel for the HOA stated here, no other unit owner somehow has a valid property interest or can claim prejudice because Mr. Accetta is no longer being overcharged in violation of Kiowa. Because effectively what's been happening is that the other unit owners may have been paying less than their fair share because Mr. Accetta has been supplementing that for a number of years. That's not necessarily legal prejudice is what we're referring to. Mr. Accetta would be entitled to that declaration. The additional relief requested in the complaint, and the complaint does request a declaration that the current allocation is void for being contrary to Kiowa and violates Kiowa. With respect to the second step of reformation, the provisions that the counsel for the HOA was citing to in terms of requiring unanimous consent and all of those different provisions, that applies to when we're talking about amending a Kiowa-compliant allocation of common interests. And that's correct. If there's an actual valid Kiowa-compliant allocation of interest, the HOA is not at liberty to simply go in and reallocate that or change it. I think the HOA's duties change drastically once we have a void provision of Kiowa. So once that declaration comes down, and I don't believe that there was any objection to that now from counsel for the HOA, but when that's made, and then we turn to the statement of a reformation claim. The HOA can absolutely take a position about what it believes to be a fair allocation. And much of the prejudice and the conflict, I think, that counsel for the HOA was referring to refers to the fact that if someone pays more, someone else is paying less. And that may be true when we're talking about what happens with respect to the existing allocation in the declaration. But once that's gone, and once that's declared invalid, now there is no allocation of common expenses in the community. In that instance, the HOA can certainly take a position as to what it believes to be a fair allocation among the different unit owners. And again, any unit owners who disagree, to the extent there are any, they could either intervene in a proceeding, there could be a vote, but there's any number of ways that the reformation itself could actually happen. And to the extent that any provision of the declaration is void or is invalid because it doesn't comply with Kiowa, that would seem to me to be a primary role of the HOA.
What do you envision the court, the district court, if you win, doing? What does the order look like? It would declare this provision invalid under Kiowa. What does the reformation piece look like? Is it an order to the parties to go ahead and reform, or is the court going to reform it itself, or what does that order look like?
And I think it would follow very closely the procedure that was at issue in the Arabelle at Vale Square case in the Court of Appeals, to where I think the first step would certainly be this needs to be reformed. And again, we say reformed, but effectively what it needs to be is that we actually need to have a provision in the declaration that complies with Kiowa and how it allocates interest, something that's fair to all unit owners. And the first step, I think, would be that, yes, this needs to be accomplished, that there currently is no valid provision in the declaration for the allocation of common expenses. The first step to that would be to have the HOA propose some type of a modification, or to have that sent to a vote of unit owners.
Does that happen in the case, or is this like does the district court case end with a mandatory injunction, thou shalt go forward and reform, judgment entered?
And I think it can happen in a number of different ways. The first way it can happen is certainly just like you stated, Justice Gabriel, is to say, well, this is void, this is invalid, and the parties need to reform it, which I think would be an acceptable outcome. Another outcome would be that the parties could currently litigate what they believe to be a fair allocation of interest. The HOA can either state, well, if this provision is void, we believe a fair allocation of interest would be based on square footage of all the units. Propose that. Have that be litigated. And again, disclose to all of the unit owners. And to the extent any disagree, they can efficiently come in and assert whatever they believe to be a more appropriate allocation. Or if they believe that a different formulation is more appropriate, they can assert that. So I think it can be handled in a number of different ways.
Mr. Prevey, let me ask, what do you want our holding to be then? Do you want us to order that it be bifurcated, and in the event that the matter's bifurcated? I mean, how do we do this? Because there are two different things going on here.
Well, I think there's two different things, but the overriding relief that's requested by Mr. Accetta in this complaint is the fact that he cannot be overcharged HOA dues in violation of Kiowa. And we believe that's a judgment he's entitled to, and that shouldn't require him to individually name hundreds of other unit owners. At this point in time, that's the declaration that we believe we're entitled to, and that's what we're seeking in this case. Because at this point in time, unless we get that ruling, the current trial court order is that as a condition of that, we have to name over hundreds of other unit owners. That not only has implications to Mr. Accetta, but implications to anyone else who may have purchased a unit where the allocation violates Kiowa. How could that ever be corrected in this instance?
So are you asking us to address that specific issue?
So with respect to that specific issue, what we would request is, we would request that the court hold that the trial court's order has to be vacated to the extent it was based on Fairway Pines, and that all unit owners don't need to be a party for that declaration. To the extent that there's going to be any further proceedings, we also believe that the court can order the parties to reform. And we would also believe that to the extent that for some reason the parties cannot reform, or they cannot reform the declaration by themselves, that then the court can also do that. And I don't believe it would also be necessary to name every single unit owner as a party in that litigation either. I believe the HOA could bring that action, or any unit owner could bring that action to have the court reform. Thank you.
Thank you. Appreciate the arguments of both counsel. case will stand submitted, and the court will be in recess until tomorrow morning at 9 o'clock.